Hi there, I'm Gordon Selassie Dapo, and this is Make It Legal. Today, I present to you 5 important lessons you need to pick from the case of Asamoah versus Gifty. Make it legal. Today, we take up the lessons. I present to you 5 of them. I promise give you 10, but I thought I should summarize all of them into 5 key lessons that you can pick up. Okay, so let's get straight to it. The 5 lessons. Lesson number 1. The first lesson I want you to pick from the case of Asamoah versus Gifty, from the further issues and the court decision, is that once a marriage meets the requirements of law, it will be declared as a valid marriage, regardless of the intentions of the parties. That is what happens in the case of Asamoah versus Gifty. Gifty contracted a marriage for purposes of visa application. She never thought it will remain valid, but she has met all the requirements that will make it a valid marriage. And the law is that once you meet all the requirements of the law that qualifies a particular arrangement, a particular right or customs as the law requires, once you meet all those requirements, the law will say that it is a valid marriage and it will remain valid. Maybe the court will say that it is voidable. It means that it is valid until it is declared invalid at some point in time. But until it is declared invalid, it remains valid. It doesn't matter what you do. You can actually go ahead and contract another marriage, ignoring that one. Once that one is still there, whether you ignore it, you don't like it, it is a valid marriage because it has met the requirements of law. So the focus always should be, what are the requirements of law in contracting this marriage? It could be an ordinance marriage, a customary law marriage, or a Mohammedan marriage. What does the law say are the requirements to contracting that marriage under the law? Once you meet those requirements, you will have a valid marriage. No two ways about that. Even if you don't like the marriage, it will be considered valid in the eyes of the law. The second lesson I want you to pick from the case is that you cannot have 2 subsisting ordinance marriages. As a person, you cannot have 2 ordinance marriages. All of them are ongoing at the same time. You know, some bad boys and girls oftentimes enter into multiple relationships and keep all of them going side by side. Guys, when it comes to marriage, you cannot do that. You cannot have 2 ordinance marriages valid at the same time. If you ever contract 2 ordinance marriage at the same time or at different times and they are all valid at the same time, all of them remain an ongoing marriage at the same time, the law is that the one which was contracted later in time will be considered invalid. You know, many often than not, the ones probably you have later in time will be the one who is your latest wife and you love her or you love him as your latest husband and you want to settle with that person instead of the first one. Once that second marriage is an ordinance marriage and the first one too is also an ordinance marriage, the law is that the second one is not valid. So you cannot have the 2 at the same time. Let me also explain. You cannot have any other marriage in addition to an ordinance marriage you have now. Take note of this. You cannot have an additional marriage to an ordinance marriage you have. For ordinance marriage, or what we call Christian marriages, or what you may call church weddings and all of that, you can only have one of it subsisting throughout your lifetime. If for any reason you have a prior one before contracting the one that is your marriage proper or the person you want to settle with proper, chances are that the one you have contracted, which is later in time, will be considered by the court to be invalid because you cannot, as we have seen in the case of Asamoah versus Gifty, you cannot have 2 valid subsisting ordinance marriages. It's just not that. You remember in the case, Gifty had an arranged marriage with one other person before Asamoah got married to her. And the court said that that marriage that she contracted with the other person, who is Eugene, although was a marriage just for convenience, just for visa application process, the law regards it as valid. And Asamoah's marriage with Gifty was also an ordinance marriage. And you cannot put the 2 ordinance marriages together. Once you put the 2 together, the latter one, which is the one with Asamoah, was considered by the court to be void, to be null. In other words, it never existed because you cannot, under the law, have 2 valid marriages. Remember, if you dare do it, if you dare go add another marriage to an existing ordinance marriage, the law says that you are not only doing something bad to your first wife or your first husband, you are actually committing a crime. Yes, it's a criminal offense under the laws of Ghana to marry additional wife, additional man, or have a second marriage in addition to an ordinance marriage. It is called the offense of bigamy. Please don't commit that crime by marrying or having an additional marriage in addition to your ordinance marriage. Learn this lesson. Don't do it. The third lesson we can pick from the case is that you can only acquire a share in your spouse's properties after the dissolution of the marriage, or after the marriage is declared null, or after divorce is granted, when you show that, number one, before you could be granted a share, either 50%, 30%, 60% of your other spouse properties after dissolution of the marriage, you must show three things. Number one, that the property is owned by the other spouse in the course of the marriage or after the marriage was contracted. Number two, you must show that it was jointly acquired by the two of you in the marriage or during the subsistence of the marriage. So you must show either of these things. The third one is that you must prove that some way, somehow, you contributed to the acquisition of the property. And the contribution could be in kind or in cash. It could be you give actual money to your wife or to your husband, and he or she has some money to it to buy the car. And that car was bought when you guys are married. Or to buy the land, and that land was purchased when you guys are married. Or to build the house, and that house was built when the two of you are married. You could actually prove that you actually gave money. Or you could also prove that you did not give money, but you provided contributions in kind. Maybe you are a woman, you could say that I ensured that I care for the children. I took care of the home as a woman. Those are my contributions in kind to the peace of mind the man has to be able to acquire the property. Therefore, you can be given a share of that property if the court thinks it's just and equitable to do so. So listen to how the court put it exactly. So in the case of Asamoah versus Gifty, the court clearly stated that the respondent who claims a share in these properties listed above must first establish the petitioner's ownership in them, and that same were acquired in the course of the marriage. It is only then that the respondent can proceed to establish her contribution to their acquisition to entitle her to a share in the same or in same. So the court is saying that three things. Number one, you need to first show that the petitioner owns the properties in question. Then number two, you have to show that they were acquired during the course of the marriage before you can proceed to establish what contribution you make to their acquisition that entitles you to some share, either 50%, 60%, or 100%. Whatever share you want, you have to show this things before you can reach the stage of getting some share of the property. The fourth lesson I need you to pick from the case is that all marriages contracted for visa application processes, once they are contracted in accordance with the law to meet the requirement of law so that they can be accepted for visa processing or for visa application processes, they are valid marriages. And those marriages under Ghanaian law are regarded as valid marriages. As long as they are not dissolved after the visa application is over or after some time has elapsed since the visa application was approved, once they are not declared void or parties have not divorced or the court did not dissolve it, it is a valid marriage and it will be respected as such. So if you have any visa application marriage, any connection marriage, any marriage for purposes of getting a visa or getting some job or doing some other things rather than just for love and affection, just take steps immediately after that event to dissolve it. If you don't dissolve it, it will be there and would matter in the future. The last and the fifth lesson I have for you that I think you could pick from the case of Asamoah Gyan versus Gifty Gyan, the case I reviewed for you a while ago. If you've not watched the video of my review of the case, I'll leave the link right at the top here. Please click on it, watch that video, and get the full facts, the issues, and then the court holdings. And I want to assure you, you would be glad you watched that video. So what is the fifth point? The fifth and last lesson I wanted to pick from this case is that you don't need to have a customary law marriage before you have an ordinance marriage. I have to explain this one because it's going to be a big fight. There is no requirement of law that before you do Christian marriage, ordinance marriage, monogamous marriage, these marriages, we call it with all these names, but they are the same. You don't need to have a customary law marriage. In other words, the law does not require of you that before you contract an ordinance marriage that will be valid in law, or before you contract a Christian marriage that will be valid in law, or before you contract a monogamous marriage that will be valid in law, you should have a customary law marriage. The law does not require it of you. It is a requirement of families. It is a requirement of practice. It is a requirement of norms. The requirement of norms, of practices, of families do not necessarily become the law. Sometimes if you want a peace of mind and you want to enjoy your marriage, you remember you're going to marry into a family. So if you want to enjoy the peace of mind with the family, you meet their requirements. So most people would have to do a traditional wedding or traditional marriage at the woman's family before they do the church wedding or the Christian marriage or the ordinance marriage. And I'm just saying that as far as the law is concerned, it's not a requirement of law that you should have the traditional marriage or the cultural marriage before you do the ordinance one. It is oftentimes a requirement of the family or the requirement of practices or the requirement of norms. I think a lot of time, because you want to enjoy your marriage and save the peace of it all, people do all of that. So the average person is going to do a traditional marriage, after knockings and all those things have been done already. And then they will do the church wedding and they will ask some receptions to enjoy. All of those things, the one that's a requirement of law is the ordinance marriage. Has steps to follow. And that is what the law requires of you. The rest of them are requirements of practices, families, and norms. Society expects us to do those things to fulfill all righteousness. So the law wouldn't hurt you if you have not done custom marriage before doing the ordinance marriage. The law would applaud you that you have made a requirement of the ordinance marriage and you are okay to have valid ordinance marriage. So that you don't look like I'm the one who is saying it. Let me read what the judge said herself so that you can appreciate it. So I'm reading from the case of Asamoah Gyan versus Gifty Gyan. What the court says that, so let me read for you. The court says clearly that there is also no requirement under the Marriages Act which makes it a condition for the parties to be married under customary law prior to a marriage under the Marriages Act. Now, what this simply means is that you're not required to have a marriage under customary law or a traditional marriage before you can have a valid ordinance marriage. That is the marriage under Part 3 of the Marriages Act. The marriage we refer to as Christian marriages, ordinance marriages, or monogamous marriages. You don't need to have the customary marriage before you could have a valid ordinance marriage. Yeah, so these are the 5 lessons I think you can pick from that case. Take this lesson seriously and use it to, do some review of your own marriage and see whether you can better things for yourself. And if you are yet to marry, be guided by it as you prepare to get married. I'm Gordon Salasi Dapo, and this is Make It Legal.
Make it legal.